I think it was important in this session, when we're talking of transforming the courts, to really get a sense of what are the cases going to courts on transgender rights, because I think most people, even within the movement, what they're familiar with are the NALSA, privacy, and the 377 decision, and not really the mundane, run-of-the-mill cases that go to court, and what's happening in those cases. So while we haven't done a study like how Carlos did, I tried to do a kind of overall, kind of search of cases, and to really see what kind of cases are going to court, how are they doing, and what are our courts really deciding. Okay, so I've divided the cases into 5 phases, just for a better understanding. So the first phase, phase 1, I have termed it like on constitutional recognition of gender identity. So these are our big cases where the Supreme Court has recognized the right to gender identity, the right to life, dignity, and the right to self-identify one's gender. So these were the big constitutional declarations in NALSA and Puttaswamy. So the privacy judgment that was discussed and the NALSA decision. The NALSA decision was in 2014 and the privacy decision was in 2017. Now, interestingly, I found that interesting that both the cases were not brought by the trans community. NALSA was brought by the National, the Legal Services Authority. Yes, there was a transgender person who was an intervener, who played obviously a very, very crucial role. But both NALSA and Puttaswamy were such important declarations on transgender, the right to gender identity was declared, were actually not brought by the trans community or even the LGBT community. Then we go on to phase 2. Following NALSA in 2014, because there was such a strong recognition of the constitutional right to self-identification of gender, or even the issue of the right to gender identity, we see a huge spurt of cases that have gone to court after 2014. And this is across many high courts. Most of the cases are really on discrimination in public employment. And I think it's really interesting, and we need to see what's happening there. So in public employment, cases are where people are not appointed in government jobs on account of their gender identity or their transgender status, or they're terminated from public employment because, again, of their transgender status. Just want to do a quick summary. There's a lot written, but I'll just summarize. So Madras High Court is actually a very, very busy court on transgender rights. There have been loads of cases in the Madras High Court. There are about 4 cases where, and what is very interesting is all the public employment cases on transgender issues are all with regard to employment as police constables. I just found that quite fascinating. Every single appointment, every single case which went to court, perhaps it's because they're talking to each other and therefore they are taking up these cases more readily to court, but all of them were with regard to termination of employment of women who were appointed as women police constables. So there were 4 cases where women were recruited in the police service as women constables, and that was an important part of the discussion in court. After they were appointed and recruited as police constables, they passed all the exams and tests and all of that. They were asked to go through medical tests. Many of them were asked to go to, some of them were asked to go through medical tests fairly later, like, after they had been appointed and already started service. In the medical examination, they were found to have a transgender identity. The medical records have recording stating them to be pseudo-hermaphrodite. These are all very outdated kind of terminology. Then, after the medical report, the petitioners were either terminated from service, or in some cases that appointments were not confirmed. There was, so the Madras High Court, kind of highlighted in these cases that one big problem is that there is no law which prescribes what is the mode for determining one's sex. I mean, the court used the word sex, but I would say it should be gender. So the court did bring it up, that there is no mode to determine what is one's gender. I mean, should it be through medical tests, or should it be through self-identification, or what? The court did rely on NALSA, where it recognized that the petitioners could choose their gender identity as female and not as transgender, because what was coming out is that the women, while applying, identified themselves as women, and they applied and got the position. But in their medical tests, the medical board identified the petitioners as transgender. So the court said that you can't be labeled a transgender if you don't choose that. You have the right to identify yourself as female. While the judgment was, in that sense, quite progressive and open, the court, it was the same judge. The judge said that, you may not want to be identified as transgender for your whole life, because then it would be difficult for you to get married. So, that was quite a contradiction. And relying on gender identity, the court said that those terminations should be set aside, and therefore your employment was protected, public employment was protected. But it also said that the petitioner had chosen to be female, but later on could choose a different identity in the future if she wanted to, because she has the right to choose her own gender identity. There was also another case of Pritika Yashini, again from the Madras High Court, where she was not, she sought to get appointed in the police force under the reservation of women, as there was no transgender category, and that was an issue raised. So those were some of the cases in the Madras High Court where all the appointments or terminations were set aside and the appointments were upheld on the issue of transgender. There was an interesting case, a very recent case in Rajasthan, in the Rajasthan High Court, of Ganga Kumari versus State of Rajasthan. Again, this was a person who had applied for appointment as a police constable, as a woman candidate, as a female candidate. She cleared her physical test, but she was not appointed. And again, she was not appointed because the medical test, the medical board didn't find her to be a woman as per her identification. But this was interesting. The court held that since her documents are in tune with her gender declaration, and no doubt has been expressed about her external characteristics and gender behavior, she should have been considered as female and be appointed. So, I find some of this language interesting to reproduce, because the court, you can see that the court is trying to recognize your right to self-identification, but the language in which it is expressing it is itself problematic. And then the court reiterated that this was important. I felt that the medical sex determination, or the test that she had to undergo, was itself a violation of the right to privacy under Article 21. And if we were to take this further, all public employment requirements and rules mandate a medical test. In India, even though you may not require a medical test for your job, you still have to do a medical test for every job in the government. So can this be taken to say that any medical test is actually a violation of the right to privacy and therefore it should not be done? Then the court said that sex determination can be ordered only if a candidate's general behavior, external characteristic, or society's perception about such candidate is contrary to the declaration he or she has made. So actually the case, if you read what the judge, so this is a problematic finding, right? Because the judge was actually trying to say in the case that, she's declared herself to be female, she appears to be female, there's no doubt, why was she asked to go through a test? She should have been appointed as a woman. But then when you put in something like this, that as long as there's no problem with your general behavior or the way society looks at you, then it's fine. But otherwise, you may be required to go through a medical test. And then the court actually, gave a general guideline that all recruitment and application forms in all departments in the government in Rajasthan should have the word gender instead of the word sex. So for many reasons, I think this is an important decision, and it's a fairly recent one of 2017. There were other cases of public employment. Again, on the issue of transgender identity. So there was an important Delhi High Court decision, the Faizan Siddiqui case. Here, the person had applied as a female constable in a paramilitary force called the Sashastra Seema Bal. And after recruitment, at the time of recruitment, she was found physically fit. So her physical tests of certain criteria were all fine, but she was found medically unfit. And the medical board, after the test, said that she was not a healthy, fit female. There were also guidelines for this particular paramilitary force recruitment that the candidate must be free from physical defects. And so those were the guidelines for that particular department. And it's a very detailed judgment. So what the medical board said is that she's not free from physical defects because we don't think she'll be able to bear a child. So that was seen to be as having a physical defect, if you're unable to bear a child. That was a specific finding made by the medical board. They also noted, it's not here, but they also noted that this woman was taking hormonal supplements, and they said that if she's sent to some border area, she will not get her medicines or medications, and therefore she is going to be medically unfit, or it's going to be very difficult. So all these reasons were given by the medical board and by the government to say that she couldn't be recruited. There was a division bench decision of the Delhi High Court where it was held that there was actually no rational basis for concluding that this woman's appointment to the SSB would jeopardize the force. So they said that if she's there at the border area and she's not able to get her hormones or medicines, she is going to actually jeopardize national security and jeopardize the force and all of that. So the court said that there's going to be no jeopardy of that kind. No evidence to exclude the petitioner from service. And the court directed that she should be considered for appointment and only her physical standards be evaluated. That means only the physical tests for which the force had. And also noted, of course it held that all those other things of her not being able to bear a child was not relevant at all, and said that, and also noted that even for medical examinations, there were no guidelines. Like there should be certain guidelines on when the government departments do medical examinations. So as we can see, there were a whole bunch of public employment cases. There were, in the same category, I put public education and reservation. There was just one case that has come to my notice of Tarika Banu, who was actually supported quite actively by Grace Banu, who's speaking tomorrow. And here, this was about an SC trans woman who wanted admission to a medical course, and the court said that she could be given admission. She shouldn't be denied admission in the reserved category. So that was, the second category of phase 2, or the public employment and public education cases. I now, I would term the third phase as the decriminalization cases. So we've had, again, a spate of the decriminalization cases. We had the 377 challenge, but I think post-NALSA, there is a new Section 377 challenge by trans activists, which is there in the Supreme Court, and challenging Section 377. There has been a challenge to Section 36A of the Karnataka Police Act, which criminalized the trans community in Karnataka. There is the Telangana Eunuchs Act challenge, which Vaijayanti will speak about her experiences as a petitioner. But just to briefly, I mean, people know what is Section 377, but I think I should just say what is the Telangana Eunuchs Act and the Karnataka Police Act, because they're very similar. The Telangana Eunuchs Act has been a 1919 legislation, so it's about 100 years old. This is a legislation that was the pre-colonial legislation enacted in the state of Andhra Pradesh and now moved to Telangana, which criminalizes transgender persons or sexual minorities or gender non-conforming persons for a variety of activities. One of the prohibited activities are appearing in female dress on public streets, singing, dancing, entertaining. So all of this can lead to arrest without warrant. There is a provision that the Commissioner of Police can maintain a record of your whereabouts because you may be suspected of kidnapping children or emasculating boys. So you can be criminalized if there is a boy under 16 found with you, because the assumption is that that boy has been kidnapped by you. So it is a really, quite a draconian pre-colonial legislation which is still lying on our statute books and was not challenged. The Police Act has one section of that. So both these local laws were challenged. Section 36A was amended. The Telangana Eunuchs Act, we have just filed a constitutional challenge in the Andhra Pradesh High Court, and we are awaiting the result. Again, I think this is also a fallout, a direct kind of fallout of NANSA. Within the same decriminalization category, I also put the case of where there are cases of freedom from violence. We've had one case where it was about a young trans girl in Delhi who was stopped by, her passport was taken away by her parents, and she was not allowed to go to the US. And that had to do with her trans identity. The court allowed her directed that the passport be returned to her. She was allowed to travel alone to the US without her family. And in fact, not only was, her parents had filed a police complaint against her, but they had also filed complaints or were harassing other people from the LGBT community who were supporting her, in whose place, she found support. And that is the story that we know is happening to many people, where, where parents are, filing complaints against their children for their gender non-conforming status, and where other groups or NGO workers are supporting them, cases are filed against them as well. So the court also directed the police not to harass or wrongfully confine anyone else, and it's basically the people who are helping her. And the court, Justice Mridul, stated that those who do not conform or render themselves vulnerable to harassment and violence, not just by the police, but also by society that ridicules them. And this is really about this girl's own family. Phase 4 is cases on change of identity, both name and gender identity in educational certificates and birth certificates. And I will just quickly go through this. We've had a lot of cases where petitions have been filed in different high courts for change of name and gender. I want to reiterate, our experience has been exactly like Peru. Name and gender identity in educational cases, all of those are from the Madras High Court, has been granted, but that in all these cases, SRS was done. The court said that where transgender persons undergo sex reassignment surgery, the department must carry out the changes. What is interesting is about birth certificates. We've not had any case of birth certificate change of gender. And the only one case is of Gujarat, where the person was intersex. And in that case, we have a law on, I should get the exact name of the law. It's called the Birth Registration Act. to that effect. And that actually says that you can only change your name or any other detail in your birth certificate if there's been a typographical error, not by choice. So the court said that we can change the sex in the birth certificate of this person because erroneously the parents had put her as male because she had a deformity, etc., and therefore the gender change was done. But we don't have other cases of gender change in birth certificates, and we filed one in Bangalore, and we'll have to see how that goes, and that's also how the law is framed. There is a Karnataka Law Commission report which says that people should have the right to change their details by choice. They only refer to name, not gender, because that was a report before NALSA. But to say that, well, you should be able to exercise your choice and autonomy in changing. And finally, the last phase is on family and property rights. This is something that we've not discussed, or it's just beginning to be taken up. And very interesting, there are a couple of cases, but I just want to focus on Sweetie versus general public. This was in Hyderabad, where a trans person had filed a suit for succession for to be the legal heir for property left behind by her chela. So in the Guru Chela system of the Hijra community and the Gharanas, where there is a completely different cultural or customary practice of family, where you live in a Guru Chela system, and that is your customary norm. So she said that she was the only legal heir based on custom. There was no respondent, or there was no defendant. So, like you said, who would be your defendant? There was no one, because nobody was opposing it. And interestingly, she had to go through 3 rounds of litigation. She went through the lowest court. Even though there was no one opposing it, the court rejected it. She went in appeal. There was nobody opposing it, but the court rejected it. And then she finally went through to the High Court. And the High Court said there is enough evidence to show that she and the deceased person had a Guru Chela relationship, because she had her Chela's name in many of the documents. So the court said that there is a relationship established through documents. So evidence is there. And this is a customary practice which we need to recognize. And actually held that she could be the heir to her Chela's property despite not having a blood relationship of family. So what are the common themes from all these cases? So some of the themes that I see is that there is a very limited understanding of NALSA in our lower courts. I would say even in the high courts, because the high courts still insist on medical documents and reassignment documents for change, and even for appointments and terminations of public employment. There is a requirement of medical transition to guarantee your right to identity. There's an overarching medicalization of impairment or deformity, and I see that to be very similar to my disability rights work, where in disability cases, everything is about the disability and impairment and not about the person. And you see that in the transgender rights cases. It's about what does your medical test say? What do you have? What do you not have? And not how you see yourself and what is needed for the job, or whatever else that you are seeking your rights for. A lot of discriminatory references to trans persons, but positively also recognition of customary practices like we saw in the last case. And where do we go from here? There certainly is a need for removal of references to medical interventions. How do we ensure that our courts recognize gender identity without medical transition? Do we need guidelines for recognition of self-identified gender so that there is, I don't know whether we need guidelines, but we need certainly something more, because what is declared in NALSA is certainly not been implemented. So how do we enforce it? What about removal of gender requirement? That hasn't happened. Should we push for that, at least in some contexts? Also, borrowing from the disability movement, the reasonable accommodation principle, where in the disability movement, the reasonable accommodation principle of equality says that you have to, like affirmative action, you provide what is needed to reasonably accommodate that person. So here, I think we need to make many of these changes as a principle of reasonable accommodation. So I will end there.